I think we have everybody. We have Mr. Bollinger and Duthier. Okay. With that in mind, we are ready to start. Both counsel are present. Mr. Bollinger, did you wish to reserve any time?
I do, Your Honor. 5 minutes, please.
Did you say 5, sir?
Yes, Your Honor.
Thank you. And counsel for the appellee, you'll find that I'm interested in surname pronunciation. I suspect you can guess why. Your sound looks to me to be a little bit French, but I'm not certain. How would I properly pronounce it?
Or Duthier's is fine.
Duthier?
Yes.
Thank
that
you.
Works.
Okay, Mr. Bollinger, you have the floor, sir, and you may proceed.
Thank you, Your Honor, and may it please the court. Let me start off by apologizing if the court becomes distracted by some background noise. My office is located downtown St. Pete, and across the street they're building a high-rise. Of course, as fate would have it, there's on and off loud noise today. They just broke ground about 2 weeks ago, but it's been very distracting. So,
gee, that new building wouldn't be the second DCA's new place of residence, would it?
Unfortunately not. No, it's a 42-foot high-rise for private individuals.
Okay, thank you.
Yeah, but if the court has problems hearing me, please let me know and I'll speak louder or try to do something. All right, so I'd like to start with the facts in this case because the facts in this case are a little bit disputed, and if the court has seen the factual renditions, they're a little bit different. So I want to start with those because it's my belief if the facts are looked at carefully, then the law in this case becomes very simple. There's really only one major issue and one main case, the Londano v. Turkey Creek case, talking about compulsory counterclaims. So I'll start with the transaction or occurrence that forms the subject matter of appellant's claim took place on September 7th, 2018, when appellant Charles Davis, who was a private individual, deposited a cashier's check made payable to him personally in the amount of $20,000 into his local and personal account with PNC Bank. Now, PNC is not involved in this appeal. The cashier's check is drawn from a Bank of America account owned by C&K Investments, LLC, which is a Missouri car dealership owned by Mr. Davis. Like all cashier's check, prior to the issuance of the check, the funds were immediately withdrawn from the Bank of America account belonging to C&K Investments before the check was issued to Mr. Davis. Then after the deposit of the cashier's check into Mr. Davis's PNC account, PNC Bank claimed for weeks that the cashier's check did not clear. Davis then contacted the appellee Bank of America, who told him the cashier's check cleared immediately. And so when Mr. Davis then informed PNC Bank that the check actually cleared a day after deposit, that he'd been lied to, PNC froze his account and started an investigation. So on January 22nd, 2018, Davis filed suit after we put PNC Bank on notice and to provide the $20,000 that were deposited and cleared months before. In any event, a month or two after suit was filed, PNC Bank suddenly withdrew $20,000 cash from Mr. Davis's frozen personal account and sent it to Bank of America to satisfy an overdraw of the C&K Investments LLC account. So Bank of America freely admits both here and below that the overdraw of the LLC account was caused by a $30,000 return check from State Farm Bank. However, Bank of America nevertheless claims it somehow is entitled to have PNC Bank take $20,000 from Davis's private account to satisfy an overdrawn account belonging to the LLC. So we later found out Bank of America provided PNC with a hold harmless and indemnification agreement so it could convince PNC to help it collect a business debt accrued by the LLC. Then during the litigation on the eve of a motion to set trial in September of 2020, PNC Bank was allowed to bring a third-party complaint against Bank of America under the indemnification agreement, even though it failed to raise the indemnification for 2 years. This derailed the case, obviously. And then again, a week or two before the next hearing on motion to set trial, Bank of America filed the current counterclaim we're on today, which again derailed the case. The counterclaim seeks declaratory relief, but it's really a disguised debt collection action, and the counterclaim seeks a declaration determining that it was allowed to recoup the cashier's check and guidance as to what to do with a cashier's check, even though one cannot recoup a check after it's been deposited for many months, especially a cashier's check, which contains certified funds. So what actually transpired between these two bank accounts is that PNC Bank and Bank of America conspired under an indemnification agreement to withdraw $20,000 cash from Davis's personal account to satisfy a business debt from the Bank of America account belonging to C&K Investments. So when the counterclaim came, it was brought under a deposit agreement that was attached to the counterclaim that has a mandatory Missouri venue provision and also a mandatory arbitration provision. So Bank of America made no argument below, and Bank of America makes no argument here to refute Davis's attempt to dismiss for improper venue or to compel.
Let me ask a question on this, because I think your brief seems to take two different positions as to the nature of the deposit agreement. Are you agreeing that your client is in fact bound by the language in the deposit agreement?
Well, I'm alleging and I'm arguing that the LLC is bound by the deposit agreement, not my client personally. My client didn't.
So if your client personally is not, if your position is correct, that your client is not personally bound by the deposit agreement, then what standing does your client have to assert a venue provision or an arbitration provision in an agreement to which your client's not a party?
Well, number one, Bank of America is asserting the opposite. They're asserting that my client is responsible, and it seems to be a question of fact is where it's left right now, because.
Well, in fact, you've also asked for attorney's fees under the terms of the deposit agreement, which seems to be seeking affirmative relief on a contract, which your client has to be a party to seek that relief, doesn't he?
Well, I do understand that. Your Honor, but if it were not for the deposit agreement, there would be no counterclaim in the first place. So this couldn't even be brought in the first place, and so it wouldn't have to be dismissed. But it is brought, and it's been alleged that my client is responsible now. So that creates a factual issue that prevents summary judgment or prevents motion to dismiss, and the case is now ongoing. And my client, in fact, is part of this. My client's been served with the counterclaim and how to respond to it. So there's no way for my client to get out. I agree with you, Your Honor. If my client ultimately is found not to be responsible under the deposit agreement, then the counterclaim couldn't have existed in the first place and would have to be dismissed. But since it's there, my client has to respond to it. So that being the case, he's being held into court under the counterclaim because it's alleged that he's responsible for this overdraw on the Bank of America account. And again, the counterclaim, it reaches back to transactions and occurrences that have nothing to do with the lawsuit at issue in this case. The lawsuit at issue in this case was brought in September, because of the September 7th, 2018 deposit of the cashier's check. Now, what Bank of America has done is they've looked at the case of Ladonna v. Turkey Creek that says that the standard is that a transaction or occurrence is what. Let me read the exact case. A compulsory counterclaim is a defendant's cause of action arising out of the transaction or occurrence that formed the subject matter of the plaintiff's claim. What Bank of America has done now is change that, calling it transactions or occurrences in the plural, so that they can annex other transactions that occurred in Missouri a year and a half prior to this, including the return of a check from State Farm Bank for $30,000, which has nothing to do with any of the claims that were brought against PNC Bank. So the level of abstraction that Bank of America argues here would allow anyone to bring a counterclaim on almost anything. You could go back to, if you use the word transactions or occurrences, you could go back in time as far as you wanted to and just annex a lot of other transactions. So we believe that the correct facts are looked at in this case, then those transactions that Bank of America now tries to bring in this debt collection or this debt collection action that's disguised in this case, couldn't be annexed, and instead that this matter should be sent to arbitration or it should be dismissed for lack of venue. The Londano case also has a logical relationship test, so that one can see whether a transaction or occurrence is actually connected. And the logical relationship test reads as follows: a claim has a logical relationship to the original claim if it arises out of the same aggregate of operative facts as the original claim in two senses. Number one, that the same aggregate of operative facts serves as the basis of both claims, or two, that the aggregate core of facts upon which the original claim rests activates additional legal rights in a plaintiff that would otherwise remain dormant. So again, in this case, neither one or number two, neither of those are applicable because, again, it's not the same aggregate facts as both claims. And number two, no additional rights were activated when this lawsuit was brought, because Bank of America could have moved forward under their deposit agreement over a year and a half before this lawsuit ever was brought, and either brought Mr. Davis personally, if they could pass the test and argue that he's personally liable under the deposit agreement, or brought the LLC. Now, what sheds a little bit of additional light on this whole issue is that Bank of America never even tried bringing the LLC into this action. They never summoned the LLC. They never served the LLC. So all this really is a way to prevent Mr. Davis from pursuing his claim against PNC Bank. And it's just in furtherance of that scheme that PNC Bank and Bank of America had in having this hold harmless agreement, so that funds could be taken out of a private personal account and sent out of state to satisfy a business debt of the LLC. And with that said, I'm open to any questions, or I'll reserve any additional time for rebuttal if I could, please.
Counsel, just to perhaps enlighten you and others who may be listening, my understanding under our court's rules of procedure and operational manual, the maximum one can reserve on rebuttal is 5. So you can reserve your 5, but I don't think you get to add on.
Okay.
So you may want to use, because you only had 10, the remaining time if you wish to, or, you know, rely on me to extend your rebuttal time should there be a real need for it.
Okay, then let me add a couple of things. Also, one of the grounds that I moved to dismiss the counterclaim was because it would require the presence of a third party, the LLC, over which the court doesn't have jurisdiction. And not only does the court not have jurisdiction, trial court doesn't have jurisdiction, and the LLC obviously will be a necessary party, since the LLC is the one who owned the Bank of America account. And so again, Bank of America doesn't even try to clear that hurdle, because Bank of America purposely hasn't summoned the LLC and hasn't served the LLC, even though the counterclaim would require the LLC to be part of it, the LLC owning the deposit agreement. So that's yet another issue. And again, the issue of the venue provision and the issue of the arbitration provision, those matters weren't opposed below, so those have been waived, and neither here in this appeal has Bank of America even made any argument counter to enforcement of the arbitration provision or the venue provision. And then going to my reply, Bank of America argues that the counterclaim is inextricably intertwined. However, it is not, because if one looks at the counterclaim, it's basically a Bank of America's request, for the trial court to uphold what it did with PNC Bank in recouping $20,000 on a cashier check that already previously cleared. However, once again, Bank of America could have brought its claim against the LLC and or Davis, if it could have held Davis liable under the deposit agreement. It could have brought that cause of action long before Davis ever filed suit against PNC Bank here in Florida. So again, it's not inextricably intertwined if a separate lawsuit or a separate arbitration could have been brought a year and a half previous. So I don't think that Bank of America's argument that its cause of action is intertwined and therefore it's a compulsory counterclaim should be well taken. And thank you. I'll rest of that.
Thank you, counsel. Counsel, you are muted before you start your response. Don't worry, it happens to me all the time. Now that we're ready, you may proceed.
Oh, there we go. Anyway, good morning, Your Honors. May it please the court. My name is Trisha Duthiers, and I represent Coapelli, Bank of America NA, which will be referred to as BANA which has been referred to and will be referred to as BANA during these proceedings. There is no error or injustice for the court to redress with regard to the lower court's denial of Davis's motion to dismiss the counterclaim or third-party claim against Davis and CSK Investment LLC, which is DBA City Limits. Davis tries to confuse the court and with the issues in his initial brief, even making illusory arguments.
Ms.
However,
Gutierrez, I have become confused. I'm not sure, though, that is all the fault of the other side. So let me work through a few issues.
sure.
First, does it continue to be your position that C&K or City Limits is a party to this appeal?
No,
Is it
No.
your position that they were made a party to the counterclaim?
in the trial court, yes.
So
They-
what document or what pleading constitutes an appearance by City Limits in this case?
The motion to dismiss, Your
Was
Honor.
it filed on its behalf?
It was filed by Davis, but it made substantive arguments on behalf of CNK.
So a party that makes arguments referring to someone else automatically makes the someone else a party to the litigation?
Well, only in this situation, Your Honor. Davis is the registered agent for CNK.
Was
He
Davis
served through
personally
counsel.
served with summons in order to bring C&K into the lawsuit?
He was served through counsel as the registered agent.
Is counsel the registered agent?
No, Davis is.
Is there
Davis
some statutory or case authority for your argument that serving a pleading on counsel for a party constitutes service on an independent entity or a related entity, but one that is constituted under the law?
Yes, Your Honor. I have the case here that says that CNK submitted itself to the jurisdiction of the court. It had notice. Maybe service may not have been perfect, but it was at most irregular
But
because.
C&K did not file anything in this case.
But as personal rep, as the registered agent for CNK and through counsel, they made a bunch of arguments. They even tried to enforce
So
the
what you're
arbitration
saying is
provision.
a party that makes arguments that refer to a non-party automatically makes that non-party a party to the litigation.
Only in this situation because he's the registered agent for the corporation. It's one and the same. He's a sole member LLC.
So service of a pleading constitutes legal service of process is what you're contending.
In this situation, we're contending that he waives service.
Okay, I understand your argument. I just don't think I agree with it. Let's turn to another issue. Are you contending that Mr. Davis is bound by the deposit agreement? I think the answer to that is yes.
Yes, he's personally liable, yes, by signing the deposit agreement.
So if he is personally a party to the agreement, then you agree he would be entitled to invoke the arbitration and venue provisions, correct?
Yes,
Okay.
as personal, but you hit it on the head, Judge Silverman. The thing is that he's been arguing that he's not personally liable. And if we
Well,
follow.
I understand that, but you've argued he is personally liable and he's a party to that agreement. So if we agree with you, then he is entitled to raise a motion to arbitrate, a motion to transfer, or to dismiss based on venue, correct?
Yes, if he is not,
Okay.
if the court does not agree that he is not liable because he signed as the manager of the LLC, then he would be. But if the court were to find that he's not personally liable because he signed as the manager, then he could not avail himself of any of the provisions of the deposit agreement. And as a matter of fact, as I was preparing for this oral argument, it really made me question, if we followed his logic and his arguments, whether or not this court had jurisdiction to hear this appeal in the first place, because it's on a motion to dismiss. And as we know, generally denials of motions to dismiss are not appealable or reviewable immediately on an interlocutory appeal.
But they are when it concerns denial of a motion to arbitrate or to transfer venue, right? We don't have it. I don't want to waste time on things that don't exist in this case. You agree that we have jurisdiction, or you don't agree we have jurisdiction?
Well, I believe that there's jurisdiction if the court agrees that he is personally liable on the deposit agreement.
Okay. Turning to the counterclaim, how is this your client was brought into the case by by PNC on an indemnification agreement, correct?
Yes.
Your counterclaim third party complaint does not challenge anything as to PNC, correct?
Well, there's answers and affirmative defenses there as to PNC,
Your
but
counterclaim,
no,
your
Right, does not.
counterclaim and your third party complaint do not raise anything as to PNC.
they do not.
Okay, so how does this constitute a counterclaim when there is no claim brought against your client by Mr. Davis?
Well, in this instance, because of the hold armless agreement, we stood in the shoes of PNC so that we could bring a counterclaim against Davis, because counterclaim, essentially, you're aligned on one
Is that
side.
what an indemnification agreement does? Does it allow you to stand in the shoes of another party?
Well, in this case,
You keep saying in this case. So as a matter of law, does an indemnification agreement give your client standing to step in the shoes of PNC and do anything?
we believe that the arguments that PNC would have against Davis, we stand in the shoes and we make those arguments on behalf of PNCs because we're holding them harmless.
But PNC is already defending the case. So are you asking to substitute for PNC?
Well, at the beginning, we were in the shoes. We were defending the case on behalf of PNC, and they've since retained counsel. But they are not part of this appeal.
You're not suggesting that Bank of America is the replacement party for PNC in this litigation?
At the moment, no, they are defending separately.
So let me turn to another issue that is puzzling to me. How is this a proper declaratory judgment action? Because what's troubling to me is your client has recouped the funds represented by the cashier's check. So it strikes me that you're not asking for an interpretation of a contract. You're not asking for an interpretation of the terms of the indemnification agreement. You're not asking for an interpretation of the terms of the cashier's check. You're not asking for an interpretation of the terms of a statute. You're asking for an opinion that says, we did this right. Our conduct was correct. How is that appropriate for declaratory relief, as opposed to being an advisory opinion?
Well, Your Honor, there is a dispute between the parties as to this check. We have already recouped the check, and there was no cause of action that we could bring to get the money back since we'd already taken it.
You already have the money back. So aren't you asking the court for an advisory opinion that says, we did this right?
Well,
Your
Honor,
you're not uncertain as to any rights. I mean, you've already acted. So this is what I'm a little puzzled by in terms of the ultimate merits, whether this is actually a correct proceeding for declaratory relief. You haven't been sued by Mr. Davis to get his money back. You didn't sue Mr. Davis to get your money back. You took control of the check, which you may have had all the right in the world to do. He's disputing that with PNC, but explain to me why this is not essentially an advisory opinion that says, Bank of America, you've done good, pat on the head. Why is that not what you're asking for in this case?
Well, Your Honor, because Davis and Banna have antagonistic and adverse interest in the cashier's check, the facts of what happened with this check are intertwined extremely with the case between Davis and PNC. And so if Davis is able to recover this money, then all of a sudden Banna is going to be liable to PNC for it.
He's not suing PNC per se on the cashier's check. I mean, I understand it's interrelated, but he is saying that they engaged in misconduct by taking the funds out of his account. Whether they did that right or wrong seems to me to be a different issue related to the cashier's check, but a different issue relating to the conduct of PNC.
Well, Your Honor, this is a thwarted attempt by Davis to basically have a windfall of this $20,000. On a motion to dismiss, which is where we are, Banna's counterclaim.
It's a motion to dismiss, but it's also a motion to compel arbitration or to transfer venue. And you have said that if Mr. Davis, if we agree Mr. Davis is a party to the deposit agreement, then he is entitled to raise the issue of transfer venue and raise the issue of arbitration.
But Your Honor, Davis sued PNC and he chose to sue PNC in Hillsborough. And the only reason why we're in this is because PNC brought us in. And so we had to bring this counterclaim because we were holding the money. And it's all intertwined. And at this point, I mean, yes, he's saying that he's suing PNC because they took the money out, but they really didn't take the money out. Once PNC investigated and realized that Davis had been using a whole bunch of social security numbers and that there was something fishy with the check because it had been deposited a year and a half after the cashier's check, way past the void deadline, that's when they contacted Bank of America. And we were like, yes, this is a check on an overdrawn account. And the deposit agreement allowed us to, you know, recoup this money, and we told PNC that we would hold them harmless. So in this situation, in order to divide this would be a race to the courthouse because PNC would be affected by this. All of these claims have to be decided together. And there was no cause of action that we could bring because we already had the money.
But you have not raised any challenge as to the indemnification agreement. You're simply raising a challenge as to Mr. Davis. Is there any reason that cannot be arbitrated?
You mean the claims between Banna and PNC?
No, you did not raise a claim between Banna and PNC in your deck action, right?
Right, we have affirmative defense.
Okay, so you have a claim that you are presenting against Mr. Davis based on the declaratory judgment. Is there any reason that could not be resolved in an arbitration proceeding?
Well, Your Honor, we believe that the claims are intertwined.
Literally, you didn't plead them as intertwined. You pleaded a claim against Mr. Davis to say, we recouped the money properly. I mean, that is a distinct claim between you and Davis. Ultimately, that may impact his claim against PNC, but is there any legal reason, setting aside for the moment PNC, is there any legal reason that the dispute between you and Davis could not be arbitrated?
Well, we believe that it would be a race to the courthouse because the judgment that would be
a really slow race to the courthouse. I mean, the cashier's check was issued 2 years ago. Your client didn't do anything about that, did it?
Well, we believe that's neither here nor there, Your Honor, whether the bank decided to pursue the money at that time or not.
You're asking this court, and you asked the trial court, to not enforce an arbitration agreement that your client has in its document and that it seeks to hold Mr. Davis liable under that document. So again, my question is very simple. As a legal matter, is there any reason this could not be arbitrated? I'm not asking you as far as factual disputes. Is there anything that legally precludes this from being arbitrated?
Other than the fact that the claims are intertwined, and so the counterclaim was compulsory in this situation. Okay. We felt that we had to bring the counterclaim because it involved exactly the check that he was trying to cash that was void, that it essentially would overdraw his account. I mean, yes, it was on funds, but it was void. And he knew exactly that depositing this check, that he knew his account was overdrawn, and yet he deposited it in a personal account at PNC. This was a check that was made in his own name. So we felt that once we were brought in by PNC, we had to bring as a counterclaim that this check is owed to us. And that since we had already recouped it, there was no other avenue or claim that we could put in. The statute, the legislation that provides for declaratory actions, basically the cases say that it should be very elastic and allowed because there's no, in this case, there was no independent claim that we could bring in this litigation other than this counterclaim to basically bring the facts to light as to what happened with this check. The statute provides that its purpose is to settle and afford relief from insecurity and uncertainty with respect to rights, statutes, and other equitable or legal relations, and is liberally administered and construed. Equity in this case demands that our counterclaim survive this motion to dismiss because it's involved.
Doesn't equity also suggest that if there is a contract that provides that either party may demand arbitration, that we enforce that as a matter of both equity and law?
Yes, it does, Your Honor. But in this case, the claims are so intertwined. I'm not sure how you sever them in one place when the check, the very check that we're talking about, is the check that is involved in the suit with PNC. It's the check that he's asking. I mean, as far as whether the money came out of his account or not, you know, it didn't. Like our facts is that the bank PNC contacted us because it felt the check was fishy, and we told it that yes, in fact, it belonged to an overdrawn account that PNC was a sole member of.
Doesn't that all provide a defense to PNC? I mean, you've got the money back. PNC says, here's the sequence of events. Mr. Davis committed some sort of fraud or engaged in some sort of misconduct. We are not liable to him because under banking regulations, we're entitled to investigate. We did so. We turned the money back to Bank of America. Isn't that a defense?
That PNC would have? Is that what you're asking,
Yeah.
Your Honor?
Yeah.
I mean, maybe, but you know, that's that's a roll of the dice here. You know, we don't know. The fact is that the facts about what happened to this check and what this check is about involve Bank of America.
Okay.
And so we felt that this counterclaim should be dealt with altogether. And obviously, so did the court. You know, the court did not.
Again, I don't want to beat this to death, but it's not a counterclaim against PNC. You know, at best, this might be a third-party claim against Mr. Davis, maybe a cross-claim, although I don't think so. But you know, it's not a counterclaim. Am I right in that, or do you disagree?
Well, I mean, the way we looked at it is that we are aligned with PNC on this issue, and so we brought, you know, a counterclaim against Mr. Davis because he was on the other. I'm sorry,
what you called it doesn't make it true, right? I mean,
well, and really, I believe the cases say to focus on the substance, and so perhaps if we called it a third-party claim, because Davis was already in. Usually, a third-party claim is when you have to bring somebody in.
So then, let me ask this question: if we conclude it's not really a counterclaim, then does that not support the idea that arbitration can go forward because it's not a compulsory counterclaim as to the party claiming against Bank of America, which is PNC? I mean, this all sounds like a civil procedure exam in law school, doesn't it?
It does. It does. Very intricate. But, you know, Your Honor, like I argued, we believe that the facts of this case, what happened with this check, is just all intertwined, and we were brought in. And so we, you know, if you call it a third-party claim, but these facts are at the root of this check that he's trying to recover and get a windfall from. So that's the reason why we brought it, and we believe that it would not be possible for the court to render a just determination on the second amended complaint that he brought to PNC without having BANA involved and the facts of what happened with this check. According to, I would like to mention that, you know, according to RD and G Leasing Inc., this case instructs us that the fact that a trial judge's written order contains one ruling which is subject to interlocutory appeal does not mean that any other ruling contained in the same order tags along and is reviewable on interlocutory appeal. So the rest of the arguments as far as his corporate immunity is not enforceable, or whether or not we stated a claim is not enforceable, is not reviewable on appeal at this juncture of the case. And I would like to conclude with the fact that We believe the law supports Banna's position that the trial court properly denied appellant's motion to dismiss Banna's counterclaim / third-party action. Equity demands that the action for declaratory relief survive, so that all of these claims can be adjudicated together. We request that the court affirm the decision of the lower court or dismiss Davis's appeal of the order denying his motion to dismiss. If the court finds that he's not a party then to the agreement, then we would request that it be dismissed for lack of jurisdiction. Thank you, Your Honors.
Thank you, counsel. We'll return to the appellant. You have your 5 minutes remaining, counsel.
Thank you, Your Honor. Let me start with, I'd like to correct something that opposing counsel stated. She said, my client used a whole bunch of different social security numbers in opening up bank accounts. That's just not true at all. And that mischaracterizes my client, who was a victim of identity fraud. He went through a program and he was issued another social security number. And apparently this is part of the reason why Bank of America conducted, or not Bank of America, but PNC conducted this long investigation that it never reached a conclusion and still hasn't provided any information on. Also, the matter that Bank of America refers to when they say the check, they should be more concerned with a State Farm Bank $30,000 check, because my client purchased a cashier's check. A cashier's check is the funds are removed immediately, they're withdrawn immediately upon issuance of the check. So once again, the facts that Bank of America requires, it could have brought a case against my client long ago, and if this matter is compelled to arbitration, it has all those facts. The facts are not intertwined with the PNC claims at all. The other issue is that Mr. Davis did not make arguments on behalf of C&K Investments. Instead, all Mr. Davis did in the appellate briefs was merely cite the law and make arguments as to why Davis cannot be held individually liable for the actions of C&K. So Mr. Davis didn't file a notice of, there was no notice of appearance filed on behalf of C&K Investments, and the motion to dismiss makes it clear that it's brought individually only on behalf of Mr. Davis, not on C&K Investments. But obviously one cannot separate the two as far as having to mention C&K Investments, because liability against Mr. Davis would only arise with liability against C&K. That's why C&K was mentioned in the motion to dismiss, but there was no relief. There's no affirmative relief being sought in the motion to dismiss for C&K Investments. Moreover, my brief included the case of Bay City Management Inc. versus Henderson, a first DCA case, which states that the case has to begin with a summons. And here in this case, there is no summons summoning C&K Investments into this case. So that being said, I again request that.
I have one question for you relating to the record, because we have limited appendices that were filed. I think opposing counsel conceded that nothing was filed under the name of C&K in the case in the record. Is that correct?
That's correct, Your Honor. Yes, nothing has been filed. There's no appearance filed. There's no motions filed on C&K's behalf, and not even a summons was issued.
Thank you.
So if there's no other questions, then I will yield the remainder of my time.
Thank you, counsel. Thank you both, and that will then conclude this presentation. On behalf of the panel, we wish you well. Please stay well, and hopefully in the future, we'll do this a little bit closer and more personal.
Thank you for
Thank you.
the report.